Okay. Okay, today is the 9th of August 2023. The time is 1800 hours, 6 o'clock in the afternoon. I'm doing Introduction to Law, IR W1501. I'm starting Learning Unit 3. The story of our law. The story of South African law spans more than 20 centuries. Different nations and their legal system influence the development and the composition of our law during these 20,000 years. This is very long time, and it is therefore impossible to tell the whole story of our law here. In this learning unit, we will briefly examine the composition of South African law against its historic background by focusing on 5 specific periods that influence the development and composition of the South African legal system. In this way, we shall see how our law began and came to what it is today. As a prerequisite for your study of learning 4 and 6, you need to have an understanding of the history of South African law. Learning outcomes. After completion of this learning unit, you should be able to name and describe the 5 periods that played a role in the development, composition of contents of South African law. Explain the influence of each of 5 periods on the development, composition, and contents of the South African law. The history of our law. The Department of Justice is organizing a conference on the origins of African legal system. The aim of the conference is to find out how the different legal systems on the African continent began and how they have developed to suit ever-changing circumstances. Jane is asked to present the introductory paper for the session of South African law. She decides to start with a short history of the development of our law. However, it is not easy to present such a short history of our law because our law has developed over a period of more than 20 centuries. Jane has to find a way to tell the story of the most important historic moments of our legal history. She has to do this without including too much detail. Activity 2.1. If you were attending the conference, what kind of information would you expect Jane to give in her paper on our legal history? Feedback. You would probably want to know where and when our law started. You would also want to know what happened after that and what influences the most important in developing and shaping the law. In the end, you would want to know what our law looks like today. Quite a lot for us to deal with. So let's get started. Discussion. As mentioned in the overview, different nations and their legal systems influence development and composition of South African law. For the purposes of our discussion, we focus on the following 5 periods in the history of our law. Roman law becomes Roman Dutch law. Roman Dutch law comes to the Cape. English law comes from Britain to the Cape. The recognition of African customary indigenous law, the establishment of a constitutional democracy in South Africa. Roman law becomes Roman Dutch law. Let us begin with part where Roman law becomes Roman Dutch law by first looking at the history of Romans and the Roman law and the answering the question how Roman law became Roman Dutch law. The history of Romans and Roman law. The rise of Roman Empire and Roman law. Roman law is a legal system that was developed by the Romans, an ancient civilization. The history of Romans started when Rome, which is still the capital of Italy, was found in 753 BC. Rome started as a small primitive community with a primitive law found in customs. This community experienced enormous growth and development through welfare and gradually became a powerful and successful society with different political periods and structures, a sophisticated culture and language, Latin, and a complex system of law, in fact, a legal science. In 27 BC, this highly developed Roman civilization became an empire and ruled much of ancient world. The Roman Empire included what is today known as a Western European, parts of Britain, North Africa, and parts of Asia, and was governed by an emperor. During the first 2 centuries AD, the Roman Empire, with its culture and law, reached its peak, highest state of development. The law applicable during this time was the classical Roman law, and it reached its highest because of the extensive writings of the jurists and to some extent the legislation promulgated by the imperial legislation. One of the most important things which the Roman Empire gave us and which has lasted until today is its legal system. This will become evident in our discussion that follows. Note, BC means before Christ. before the birth of Christ, after the birth of Christ. Okay. The split of the Roman Empire and the decline of Roman law. From AD 284, the decline of the Roman Empire and the Roman law started. Factors that contributed to the decline included the invasion of Germanics, also known as barbarics, government corruption and political instability, luxurious lifestyles, economic problems, and loss of community mores. At the end of the 4th century AD, the Roman Empire split into two parts: the Western Roman Empire, with Rome as its capital, and the Eastern Roman Empire, with Byzantium or Constantinople, today Istanbul in Turkey, as its capital. After the split of the Roman Empire, the importance of Rome law began to decline. Yet it survived. The old classical Roman law survived more successfully in the Eastern European Empire than in the Western Roman Empire. Let us look at the survival of the Roman law in these empires. The Western Roman Empire. The Western Roman Empire fell in AD 476 when Germanic tribes who lived all over Western Europe took over the Western Roman Empire. As a result, government structures of the Western Roman Empire started to disintegrate, fall apart, and Germanic law influenced the classical Roman law. However, Roman law remained alive and contributed to the reception of Roman law into Europe in later centuries. We now look at the two reasons of the survival of Roman law in the Western Empire after the Germanic invasion, namely the personality principle and the role of the Roman Catholic Church. Personality principle. When the Germanic tribes took over the Western Roman Empire, and Germanic tribe had its own law, during this time, the personality principle applied. This meant that each person lived according to the law of his or her own tribe. Many of the Germanic rulers allowed their Roman subjects to continue applying Roman law. This law, however, was not the pure classic Roman law of the earlier Roman Empire, but Roman law that was influenced by Germanic law. Note: the idea that different legal systems apply in different people living in the same territory is not foreign in modern times. A good example is the administration of justice in South Africa before the constitutional era. During that time, different African customary legal systems applied exclusively to different black people. Thus, for example, a marriage between two Tswana people was regulated by Tswana law. Today, specific African customary law are still applied in certain circumstances, even though the application of African customary law is strictly regulated by legislation. The role of Roman Catholic Church. Another reason For the survival of Roman law after the fall of the Western Roman Empire was the role played by the Roman Catholic Church. The Catholic Church was a powerful and organized institution during this time. It had its seat in Rome and was headed by the Pope. Roman law formed the foundation of the law of the Catholic Church. This church law of the Roman Catholic Church later became known as canon law. Special church courts decided not only on church matters but also on a number of everyday matters such as questions regarding marriage and the validity of contracts. Canon law had an important influence on the development of modern law. It is, for example, because of the canon law that we had inherited the principle that mere agreement between two people can be enforced by law. The Eastern European Empire. The Eastern Roman Empire continued to exist until 1453. The Eastern Roman Empire was a Greek civilization with a Greek culture that never adopted Roman culture. Since the law of the Eastern Roman Empire was influenced by Greek culture and not Roman culture, the law of the Eastern Roman Empire did not really influence the legal system of Western Europe. It was only Justinian, the emperor of the Eastern Roman Empire, from AD 527 to AD 565, who played a role in the survival of classical Roman law in the Eastern Roman Empire. Therefore, we will focus on his reign. Justinian codification of the Roman law. By the time Justinian became emperor in the 6th century, the law was a disorganized mixture of different kinds of law, including legal opinions of different Roman jurisdicts and legislation of several Roman emperors before him. Justinian's ideal goal was to reunite the Western Roman Empire and the Eastern Roman Empire and to restore it to its former glory. In order to do this, he decided to codify Roman law as a whole. Codify meant that he decided that all the earlier writings of the classical jurists and all the laws that had been passed during the time of the emperors were to be collected and written down as a code. This collection of Roman law by Justinian was called the Corpus Iuris Civilis. Justinian did not succeed in reuniting the two empires, but by codifying the law, he kept Roman law alive in the Eastern Roman Empire. In this way, he contributed to the reception of the Roman in Europe many centuries later. How did Roman law become Roman Dutch law? The revival of Roman law in Europe. After Justinian's death, his codification of the law The Corpus Juris Civilis was forgotten for many centuries. In the 12th century, there was a renewed interest in Roman law. Medieval universities like the University of Bologna in Italy studying Roman law as a contained in Justinian's codification. It was because of these medieval universities that Roman law spread throughout Europe. The reception of Roman law in Europe, however, it was really only later in the 15th, 16th, and 17th centuries that the true reception of Roman law took place in Europe. It is the reception of Roman law in it is the reception of Roman law in the Netherlands that is particularly important for our history. Roman law was received into Europe at the time when the existing legal system in Europe were unsystematic and unscientific. These systems were also fragmented. In other words, there were many different kinds of systems. These medieval jurists who had studied Roman law knew that legal systems such as Roman law with its scientific method was extremely desirable. Soon these jurists began to look at the laws of their own countries through Roman eyes. In this way, they could see how that which was lacking in their own legal system could be improved through the use of the solutions contained in Roman law. In the whole of Western Europe, therefore, the use of Roman law to fulfill the needs of everyday legal practice proved to be the force which united legal systems of the different European countries. At the risk of oversimplification, we may say that if a particular problem in a particular place or region could not be solved appropriately by a rule of the customary law of that particular place or region, or if no such rule exists, jurists would look to Roman law for solution. Roman law, as explained by the medieval jurists, would then become meshed joined with the existing law. In this way, most of what was contained in the codification of the Justinian was received in Europe. In the Netherlands, it was the reception of Roman law that caused the creation of what was called Roman Dutch law. In the same way, Roman French law, Roman Germany law, and so on was created. In this way, a common Western legal tradition began in Europe. Our focus is on Netherlands, where various jurists wrote commentaries in Roman Dutch law. The commentaries were used, for example, as notes for students or as guides for legal practice. Some of the important Roman Dutch law jurists who are also known as the Old Authorities, Hugo de Groot, Simon van Jeven, Johannes van der Linden, and Johannes Voet. Their writings are still used today as a source of reference in our courts. Note: Roman law is an independent legal system no longer applied anywhere in the world today. However, it is very important to know that Roman law, for example, Justinian Corpus Juris Civilis, is still relevant in our law. South African courts continue to recognize Roman law as an important part of the Roman Dutch law, which in turn forms part of our South African common law. See Learning Unit 6. In the case of Hendricks and others, the Supreme Court of Appeal relied on Roman substantive law and referred to Justinian Corpus Juris Civilis with regards to personal servitude. The court pointed out that Justinian viewed personal servitude was adopted by the old writers of Roman Dutch law and then accepted in South Africa case law. For example, in a case of Kitson and another, Jim Speed Enterprises, CC and others. Even the Constitutional Court illustrates the continued relevance of Roman law in our law today. In the case of Paulson and another versus Slipknot Investments, 777 Pty Ltd, on the historical development of a specific private law rule, the Constitutional Court states that this rule has its origins in the classical Roman law. The rule then became part of the Roman Dutch law as writings by the various old authorities prove and has been part of our case law since 1830. Roman Dutch law comes to Cape Town. The Netherlands has a specific place in the history of our South African law. Roman Dutch law was the law of the province of Holland. It was the leading law in the Netherlands in the 17th centuries. Let us look at how Roman Dutch law was brought to South Africa and why it formed such an important part of the law of South Africa. All right, let's move on. Roman Dutch law comes from Netherlands to the Cape. The Netherlands experienced significant economic growth in the 17th century, and commercial trade started between the Netherlands and the East India and Indonesia via the sea route of the Cape of Good Hope. The government of the Netherlands appointed the Dutch East India Company to control the Dutch colonies' territories in the east. Jan van Riebeeck, an employee of the Dutch East India Company, came to the Cape in 1652 to start a trading port and refreshment station for the ships on their journey from the Netherlands to the east. The Dutch East India Company applied Roman Dutch law in all its colonies. This was also the case in the Cape. The Dutch settlement at the Cape lived according to the Roman Dutch law because this was the law that they knew and were accustomed to. We can therefore accept that Roman Dutch law became applicable in the Cape through custom. The Dutch governed the Cape from 1652 to 1795. Over these almost 150 years, the settlement of the Cape expanded and the Roman Dutch law was further developed. During this period, law was found in custom, legislation, and the old writers on Roman Dutch law, for example, Hugo de Groot, Simon van Leeuwen, Johannes van Leyden, and Johannes Voet, and court decision. If we look at the records of the old Cape Court cases, we will see that when there were disputes, judges and advocates consulted Roman Dutch law as discussed by these Roman Dutch jurists. The importance of Roman Dutch law. We mentioned above that our courts still use the writings of the Roman Dutch jurists. This has become the practice of our courts throughout our history, and so Roman Dutch law has become part of our legal tradition. It is this Roman Dutch law that still today forms the backbone of most of our law. Because we have this tradition, we are able to make use scientifically of the knowledge and wisdom of all the great minds who have written about and practiced law for more than 2,000 years. More importantly, our Roman Dutch legal system makes it easy for modern South African lawyers to communicate and interact with lawyers in many countries across the world. The reason that they can do this is because Roman law forms the basis of the laws of almost all countries in the Western and Eastern Europe, South America, and also in the laws of Japan. In addition, Roman law is still studied by law students not only in the countries we have just mentioned, but also in other countries in Africa, Asia, notable the People's Republic of China, and in the Russian Federation, as well as the United Kingdom, Australia, New Zealand, and in some of the states of the United States of America. English law comes from Britain to the Cape. The British occupied the Cape first in 1795 and then later in 1806. Under the British control, the Cape became an English colony. The British government decided that it would not deliberately change the law of its new colony and allow the continued application of Roman Dutch law. In spite of the British government decision, the influence of English law was still felt, particularly after the 1820 settlers arrived in the Cape and the British government started a policy of Anglicization. The purpose of the policy was to replace the existing Dutch language, culture, and legal administration with those of the English. Thus, for example, English became the official language in the Cape. Since 1828, the use of English court structure and formal law, procedural law, paved the way for the reception of English law into the existing Dutch legal administration. Although the British authorities never abolished Roman Dutch law as the legal system of the Cape, the influence of English law and Roman Dutch law increased, especially through courts, legislation, and court decision. Here are some examples. The British government slowly got rid of the existing court structure of the Cape and replaced it with the English court structure. Legislation introduced the English jury system. It was finally discontinued in South Africa in 1969. The English law of the criminal procedure, law of civil procedure, and law of evidence were received through legislation in the Cape. This led to the greater focus on the use of English procedural law courts. British statutes formed the basis of numerous Cape statutes. The Cape received, for example, the English Insolvency Act and the whole of the English Companies Act. Judges and advocates had to receive their training in England. Because of this, judges and advocates often turned to English law rather than to the old Roman Dutch authorities written in Latin or Dutch when deciding court decisions or solving legal problems. British influence, what was felt in a legal development of the English colonies outside the Cape from 1838 to 1910. English law was increasingly received in Natal, and after the annexation takeover of the Transvaal and Free State republics by British in the 19th century, English influence spread throughout the rest of South Africa. In 1910, the British government formed the Union of South Africa when they decided to combine the four colonies, the Cape, Natal, Transvaal, and the Orange Free State. Also in 1910, the Appellate Division of Supreme Court, today the Supreme Court of Appeal, was established. The formation of the Union, and specifically the establishment of the Appellate Division of the Supreme Court, played an important role in the merging, combining the Roman Dutch law and English law to form an independent and single law of South Africa. This law, known as common law, forms the foundation of our South African legal system. Common law was, until the 1990s, officially the only law of South Africa. Note: keep in mind that Roman Dutch law, as influenced by English law, forms one of the components, the historical component of one of our present-day sources of law, namely common law. Further discussion on present-day common law as a source of law will follow in Learning Unit 6, which deals with the sources of South African law. The role of South African customary indigenous law. The composition of African customary indigenous law at the Cape when the Dutch arrived. When Jan van Riebeeck arrived at the Cape in 1652, there were many different indigenous African tribes in southern Africa who had been living in the Cape for many centuries according to their own laws and cultures. Their laws were unwritten because they lived in communities where writing was unknown. Their laws, therefore, consisted of oral traditions or unwritten customs that were handed down from generation to generation. These laws are known as African customary indigenous law. During the time van Riebeeck and Dutch settlement, the African tribes continued to live according to their customs. The Dutch authorities did not interfere with the different tribes' customary laws. The Dutch authorities neither interfered with nor recognized any customary law of the indigenous African tribes. The position of an African customary indigenous law from the British arrival to apartheid. The position of African customary law from British arrival, from the arrival to apartheid. When the British government took control of the Cape, they initially ignored African customary law. It was also during the second half of the 19th century that the British colonial authorities in Natal, the Cape, and the Orange Free State officially and formally began to recognize African customary law, each by means of its policy in the form of written codification or code. These colonial policies laid the foundation for the official formal policy towards African customary law in South Africa in later years. Major political transition changes such as when South Africa became a union in 1910, when South Africa became a republic in 1961, and when the tricameral parliament was established in 1983, brought about little or no change with respect to customary law. During the post-colonial period and the era of apartheid, a uniform one policy for the whole South African regarding the recognition and application of African customary was laid down in legislation, for example, the Black Administration Act of 1927 and the Special Court for Black Abolition Act of 1986. During all these years, the indigenous African population attitude towards governments policy regarding African customary law was extremely negative because government policies were, in the main, discriminatory and unjust. Consequently, official African customary law legislation was largely ignored and unofficial African customary law, unwritten customary became more important. The position of African customary indigenous law since the establishment of our constitutional democracy. From the discussion above, it is clear that the African customary has always been held in an inferior position in South African law and and was recognized as a special law that only applied to the indigenous African people in South Africa. Lawyers, academics, and legal administrators focused on Roman Dutch law and English law. An important element of the discontent of the indigenous population during the colonization and apartheid was the government's refusal to give formal recognition to African customary law. The introduction of our new constitution, democracy, in 1996 brought about important changes in the recognition and application of African customary law. The Constitution of 1990 finally recognized African customary law as part of the development and composition of South African law. Section 211, subsection 3 of the Constitution gives it official, formal status in the South African law and provides that the court must apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. Today, African customary law plays an increasingly important in the development of South African law. It still develops within the indigenous communities and is largely made up of oral or unwritten customs handed down from generation to generation living customary law. Although it has to some extent has been recorded in writing, for example in legislation, court decisions, and textbooks. Official customary law, most Importantly, in terms of Section 211, subsection 3 of the Constitution, courts must apply African customary law except if it is found to be contrary with the principles of the Constitution. Further discussion on customary indigenous law as a source of law will follow in Learning Unit 6, which deals with the sources of South African law. The establishment of the constitutional democracy in South Africa. The apartheid regime era. Although the apartheid regime era started in 1948 when the National Party won an all-white election, a policy of separating the different races was conceptualized as early as 1905. The laws of apartheid were found in the statutes of parliament legislation and not in the Roman Dutch law or English law, since these legal systems are known for their principles of justness, fairness, and equality. During the apartheid regime, Parliament was supreme and could pass any legislation, no matter how unjust, oppressive, racist, or discriminatory. Go back to the Learning Unit 1 and read Activity 1.5 on the Group Areas Act of 1950 is an example of unfair and discriminatory legislation by this regime. No wonder the majority of the indigenous South African population trusted neither the law nor its application. Therefore, it comes as no surprise that the legislation of the apartheid regime was met with resistance, specifically by the National Liberation Movement of the 1990s. Initially, the liberation movement resisted through a non-violent protest, but later through an armed struggle. The history and actions of the National Liberation Movement played a significant role in the development and establishment of our constitutional democracy, as we will see in the discussion below. South African first democratic constitution. The Constitution of 1996 is South Africa's first democratic constitution. Before this, there were three other constitutions: the 1910 Constitution, when the Union of South Africa was formed, the 1961 Constitution, when the South Africa became a republic, and the 1983 Constitution that established the tricameral parliament. The tricameral parliament was parliament with three houses, one for each of the white, Indian, colored population groups. These constitutions were not democratic because only a small number of South Africans had the right to vote. The people who had the right to vote were made up mainly of whites in the country, and later on the Indians and colored people as well. However, Indians and colored were represented inadequately and had a very little voice with regards to the right to vote. The system was unfair to the black majority in the country and was met with resistance, especially by the National Liberation Movement mentioned above. Opposition against this apartheid-style government increased until it exploded in riots such as those of Sharpeville in 1960 and Soweto in 1976. There was growing pressure against apartheid from the international community, and this pressure took the form of sanctions. Sanctions are a form of punishment penalty intended to force government to have to behave in a way that it is internationally accepted. For example, it may take the form of a ban on the most important certain goods such as weapons. Black leaders within the country also put pressure on the South African government. All of this pressure led to the release of Nelson Mandela and the unbanning of the previously banned black resistance movements, the Pan-Africanist Congress and the African National Congress in 1990. These actions made it possible for negotiations to begin with the aim of establishment of full democracy in terms of the interim temporary constitution with the Bill of Rights. The interim constitution adopted in 1993. The interim constitution came into effect on the day of the first democratic election, that is 27 April 1994. It was the product of negotiation which resulted in a multi-party conference at the World Trade Center in Kempton Park. All interested political parties and political groupings participated in this multi-party conference. This constitutional was called an interim constitution because it was not written by democratic elected government, and because its existence was limited to 2 years. It was written into interim constitution that a democratic elected constitution making body called the Constitutional Assembly was to be given the task of writing the final constitution. All South Africans were given the opportunity to give their views, and great care was taken to write the final constitution in the kind of language that every citizens could understand. The interim constitution also set out 34 constitutional principles, and the final constitution had to be complied with these principles before it could be certified by the Constitutional Court. The final constitution written by the Constitutional Assembly was certified by the Constitutional Court on the 4th of December 1996. The adoption of the first democratic constitution of the Republic of South Africa is an important event in the development of the history of our law. Further discussion on the Constitution follows in Learning Unit 7 to 10. Note: from our brief historical overview of the development and composition of South African law, it is evident that South Africa has a complex legal system and that legal pluralism prevails in our country. Let us explain what we mean by the concept legal pluralism. South African multicultural society consists of various communities such as Hindu, Muslim, Indigenous, African, and broadly speaking, Western and European communities. Therefore, various more than one system of law are applied in South Africa, and as a result, result in legal pluralism prevail in South Africa. However, not all these systems are officially recognized. The official state law, which still forms the foundation of South African legal system, is the Roman Dutch law as influenced by English law. Until the 1990s, this was officially the only law South Africa. However, since the adoption of the Constitution of 1996, African customary indigenous law has also been officially recognized in the Constitution as part of the South African legal system. That is where we end. We've got activities. We've got activities up until 5. From 1 to 5. Activity 3.2. Okay, here we need to name the legal system that officially played a role in the development and composition of South African law. 2. Several factors contributed in the reception of English law at the time of the British occupation of the Cape during 1806 to 1910. Which of the following did not form part of these factors? Number 3, consider the following 2 statements. Since the establishment of the Appellate Division of the Supreme Court in South Africa in 1910, African customary indigenous law played a role in the development and composition of South African law. Today, African customary law, indigenous law, is largely recorded in writing, for example, in legislation, court decisions, and textbook. Which option is correct? Indicate whether the following statement is correct or incorrect and give reasons for your answer. South Africa has had numerous constitutions during the course of the history of South Africa. Explain the difference between the interim constitution of 1993 and the final constitution 1996. And we have the feedback here. Number 1, Roman Dutch law, answer, English law, and African customary indigenous law officially played a role in development and composition of South African law. Now you may well ask, why did not include Roman law in our list of legal system? Roman law as an independent legal system did not officially play a role, but the Roman law that forms part of the Roman Dutch law. In other words, Roman law which was received into Dutch law to form Roman Dutch law played a role in the development and composition of South African law. Option 1, 2, and 3 are all factors contributed to English law at the time of the British occupation in the Cape during 1806 to 1810. Option 4 is the option that you had to choose because it refers to the English customary law, which was not a factor that influenced the Roman Dutch law. The influence of English law on Roman Dutch law mainly occurred through court legislation and court decision, and not customary law. Question 3. Statement A is incorrect. Only since the adoption of the Constitution in the 1990s has African customary law has been playing a role in the development and composition of South African law. Statement B is also incorrect. Since statement A and B are incorrect, option 2 is correct and the one you had to choose. Question 4. This statement is correct. South Africa has numerous constitutions during the course of history. And the constitutions are named. The interim constitution of 1990 was not a democratic constitution because it was not written by a democratically elected government, whereas the final constitution in 1996 is democratic constitution because it was written by a democratic elected constitution making body called the Constitutional Assembly.